Hello everyone, good evening. Hello Krishna, am I audible? Visible to you? Yeah, good evening. Hello Krishna, am I audible to you? Okay. Any doubts in yesterday's lecture? So let's move ahead. Let's discuss further on other fundamental rights. So these are like basically now we'll discuss about right to equality today. So it talks about equality before the law, prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, Article 15, equality of opportunity in matters of public employment, Article 16, Article 17, abolition of untouchability, and Article 18, abolition of titles. So all these 1, 2, 3, 4, 5 articles gets covered under right to equality, starting from Article 14, 15, 16, 17 and 18. Just write this, that under right to equality it covers 5 articles starting from Article 14 to Article 18. And what are these articles? These refers to equality before the law, provisions on discrimination, equality of opportunities in public services or public employment, abolition of untouchability and abolition of titles. So now you know that what are the criteria or what are the categories of rights provided under right to equality under fundamental rights. And in this regard, today we will discuss in detail about the concept of reservation, because reservation can also be found under Article 14. Reservation can be found under Article 14, 15 and 16. It's an implicit part of the equality chapter under the Constitution of India. Okay. Now this part of fundamental rights corresponds with Universal Declaration of Human Rights. Have you heard about this term? Universal Declaration of Human Rights. And under this, look at Article 7, it says all are equal before the law. So the concept of equality is also highlighted under Universal Declaration of Human Rights. All are equal before the law and are entitled without any discrimination to equal protection of the law. So all are equal before the law. So two concepts, equal before the law and are entitled without any discrimination to equal protection of the laws. So the concept of EBL and EPL comes into picture here. Krishna, have you heard about these two different concepts of EBL and EPL? These, equality before the law and equal protection of the law. And Article 10 of UDHR says everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in the determination of their rights and obligations and of any criminal charge against them. So if there are any charges framed against such person, it shall be heard by an independent court which is fair in its judgment, which is fair in its treatment. Again, it embodies the principles of fairness, and overall we can say it embodies the principles of natural justice. So UDHR or Universal Declaration of Human Rights was a declaration issued by the United Nations, and these declarations are generally followed by most countries, and India also incorporated most provisions of the declaration. We'll discuss about equal protection of the law. Now on similar note, like with respect to Article 7, it says all are equal before the law. all are equal before the law and are entitled without any discrimination to equal protection of the law. Now look at our Article 14. It says state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. So here also both concepts are there. Now please understand the meaning of equality before the law and equal protection of the laws. When we say equality before the law, then it means that all are equal before the law. The law is blind. In this regard, the law is blind. And I'll give you an example for this. When we say the law is blind, let's say there is a race. And the race is among 5 children. One of the children, or let's say 2 of the children, 2 among these 5 children are physically disabled. Do you think if these 2 people who are physically disabled are made to run along with other normal children, will it be a fair race? No, of course not. But if we look at this perspective of equality before the law, then in this regard, it will not consider whether there were any disadvantage to any group of people. It will not consider any disadvantage which has been given to certain group of people. Now, so is the concept of historical discrimination. Which has been done with certain communities in India, particularly the Dalits, scheduled caste and scheduled tribes. Would you agree on this? That they have been denied opportunity, they were not considered equal from the past, and this is because of the structure of the Indian society, which was initially mostly based on caste, right? Even Dr. B.R. Ambedkar himself was a Dalit, and he also highlighted about his sufferings during his childhood. So when we only talk about equality before the law, in this regard, what we have studied is that equality before the law is blind. In such regard, law is blind. It simply says you all are equal. It does not consider any disadvantage or any any issues with respect to someone's background. उसको कोई फर्क नहीं पड़ता. So this is the meaning of equality before the law, and this concept was given by A.V. Dicey, a British jurist, a British scholar, A.V. Dicey. He gave this concept of equality before the law. Okay? Can you hear me, Krishna? Okay, great. Abhi clear hai? Equality before the law is clear to you, Krishna? At least? So, we'll discuss it. Yes, everyone is equal. It will not consider any sort of exception, basically. But considering the structure and history of Indian society, considering the structure and history of Indian society, as I've told you, Indian Constitution is also a social document, right? Remember? So now we will understand why it is also a social document. So considering the structure and history of Indian society, this idea of equal protection of the laws was also incorporated. So when we talk about equal protection of the law, then the law is not blind. Then the law looks into different types of discrimination which is taking place in the society and accordingly ensures equality among them. So what it does is that it creates categories of people. It creates categories of people, and we are now talking about equal protection of the law. Equal protection of the law. This is not blind. This is not blind, and hence it can create certain categories of people who can be considered to be at certain disadvantageous position, or who has been meted out with certain disadvantage. So if some category of people or community or caste or class were given certain disadvantage or had certain disadvantage in the past, they had certain disadvantage in the past or even in the present, then law will create certain special provisions for such categories of people. Special provisions for such category of people to address their concerns. To address their concerns. Is it okay? No, they are not saying. This is what I am telling you. Equal protection of the law is, first of all, it is not blind. The law is not blind. The law looks into various aspects of discrimination. I'll give you two examples. Okay? Krishna, first of all, do you understand this part? So Article 14 basically has two elements. Article 14 has two elements. First, equality before the law, and second, equal protection of the laws. Is it clear? Article 14 has two different components, both equality before the law and also equal protection of the law. And that's why, based on this idea of equal protection of the law, the government is able to provide certain special provision to address the concerns of certain community in case they have been at a disadvantage. Yes, teacher providing certain extra classes for the weak students to cater for their well-being. Perfect. I'll give you another example of equal protection of the law. Suppose, actually this is a true case. Actually facts, when we understand the facts, it becomes easier. So there was this lady who was to board a flight. ठीक है, उनको SpiceJet जो flight है, she has to board this flight, but she was suffering from a mental condition called cerebral palsy. So she was suffering from this mental condition. Now because of this mental condition of that lady, the name of the lady was Jija Ghosh, she was not allowed to board the plane. She was deboarded from the plane. So because of this mental condition, she was deboarded from the plane. She was deboarded from the plane, from the aircraft. Do you think it was a good decision by the members of aircraft? क्या ये सही decision था? No, absolutely not. And it is here where court highlighted this understanding of equal protection of the law, especially for certain people who are at certain disadvantaged situation. Do you understand this now? And one such category of providing this special provision is reservation. So reservation is basically an idea implicit under Article 14 itself, as a part of equal protection of the laws. Krishna, clear? Reservation hence is an idea implicit within Article 14 to provide special provisions or special protection to certain category of people who have been at certain disadvantage, to ensure that their disadvantage or their concerns are addressed. That's why we have reservation. Now, do you think reservation is a bad idea? Considering the structure of Indian society and of course our past. So, Indian Constitution has also taken care of our society, its structure, and also the past performances or past activities of certain caste or class of people. And that's why, yes, to bring them into the mainstream, correct. And that's why Article 15 also says, so Article 14 and 15 should be looked together. Article 14 kya bola? Equal protection of the laws. And Article 15 kya bola? You cannot discriminate on any ground, or at least on certain grounds. So fundamentally this is the basic idea for reservation, and this special provision is also referred as affirmative action or positive action. Affirmative action or positive action. And that's why this idea of equal protection of the law is also referred as a positive concept. And equality before the law, since it is caste blind, color blind, law blind, it is considered as a negative concept. Do you understand this meaning? See, Krishna, hota kya hai na, log yaad kar lete hain. EBL is negative, EPL is positive. Why? They at times tend to forget and are not able to write in the exam. So through these examples, I am sure आपको बेहतर समझ में आएगा. You will understand it in a better way. Krishna, so far any doubts regarding equality, discrimination, etc., etc.? Are you following everything whatever I am discussing? Perfect. तो अब देखते हैं क्या है ये. See this, equality before the law. The concept of equality before the law is of British origin, and this concept means absence of any special privilege in favor of any person. ठीक है? The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and no person, whether rich or poor, high or low, official or non-official, is above the law. So it does not consider any exception at all. Equality before the law does not consider any exception, and for them law is blind. It cannot see and doesn't matter. Is it a wrong thing? No, it's not a wrong thing, but it depends. It depends on circumstances, depends on society. At times may be correct, at times it may not provide that kind of a justice which a society actually needs. And hence this idea of equal protection of the law, and it says this concept has been taken from the American Constitution. See this. So equal protection, equality before the law is of British origin, and equal protection of the law has been taken from American Constitution. Clear? The affirmative action part has been taken from the American Constitution. So it says this concept connotes the equality of treatment under equal circumstances, both in privileges conferred and liabilities imposed by the laws. The similar application of the same laws to all persons who are similarly situated, and like should be treated alike without any discrimination. Now this is the most important or most fundamental principle of equal protection of the law, that likes are to be treated alike, or likes and alikes cannot be treated in a similar manner. So it says thus the former, that is equality before the law, is a negative concept, while this is a positive concept. Can you now write some points on your own with respect to equality before the law and equal protection of the law under Article 14? Perfect. So it says concept of equality before the law is an element of rule of law propounded by A.B. Dicey, and he has proposed these three important aspects. What are these? Absence of arbitrary power, that is no man can be punished except for a breach of law. Fine. equality before the law, that is equal subjection of all citizens, again does not matter who those citizens are, to the ordinary law of the land administered by the ordinary law courts, and the primacy of the rights of the individual, that is constitution is the result of the rights of the individual as defined and enforced by the courts of the law rather than the constitution being the source of the individual rights. Now in this regard, equality before the law, there is one development which has actually taken place. I think it was done by former Chief Justice of India, Justice Chandrachud. Do you remember the before the Supreme Court there is this lady whose eyes were tied, है ना, कहता ना कानून अंधा होता है types. So that was the idea of equality before the law, that it does not see who is before it. The idea was that the judgment should be fair, but that black ribbon before the lady justice has been removed, because now it also has to see, that is an idea proposed through the concept of equal protection of the laws, that law cannot be blind all the time. It has to see that who are the applicant before them and what sort of disadvantage or what sort of concerns they are coming before the court with. So that is why that idea. So see, so this concept has another important aspects, okay, regarding rule of law. Article 14, since it talks about two concepts, EBL and EPL. So this is a negative concept and this one is a positive concept, right? And the idea is that Article 14, through this, by saying that like should be treated alike, and hence it says that based on this it provides for a concept of reasonable classification. It provides for a concept of reasonable classification, meaning certain class of people, certain category of people, let's say general category, other backward class, scheduled caste, scheduled tribe, such categories of people can be created and these should be judged on their respective level. That's why you have separate cut-off marks for general category, for OBC category, scheduled caste category and scheduled tribe category, and now we also have another category of EWS. Correct? Am I correct, Krishna? So this is the idea behind reasonable classification. Now reasonable classification is again based on another understanding. The idea of reasonable classification is that when you provide for reasonable classification, then two things are there, that there has to be a law which provides for reasonable classification, and this reasonable classification, let's say you are categorizing people as EWS, general, OBC, SC and ST. For what purpose? For recruiting or for the recruitment process of civil services. So that is the objective, recruitment for civil services. Recruitment for civil services. So I'll ask you this, do you think this reasonable classification of this category of people for the recruitment of civil servants, is it a fair criteria? Is this classification reasonable? Is this classification reasonable? Yes, Krishna? Yes, equal protection of the law. But I'm not asking that. Yes, it's a part of equal protection of the law. But the point what I'm asking is this classification for recruitment of civil servants, they are recruited under different categories. Is this fair? Do you think this is a fair criteria? या गलत है कुछ इसमें? Well, what do you think? See, any reasonable classification must have a rational nexus with the objective which it seeks to achieve. With the objective which it seeks to achieve. So what is the objective here in this regard? The objective is to recruit civil servants. Do you agree? The objective is to recruit civil servants in this case. And the criteria chosen is, the rational nexus is to provide reservation to different categories of people. Why? Because it has been constitutionally mandated. क्यों ऐसा हम कर रहे हैं? Because this has been constitutionally mandated under Article 16 particularly. Similarly, reservation is provided under educational institutions under Article 15. Suppose करो आप IIT का एग्जाम दे रहे हो, नीट का एग्जाम दे रहे हो, या क्लैट दे रहे हो, लॉ के लिए एग्जाम दे रहे हो, या कोई भी एग्जाम दे रहे हो, सो वहाँ पे भी ये रिजर्वेशन अप्लाई होगा. Certain categories, people will be categorized as per their category. Why? Because this is an example of reasonable classification. For what purpose? Let's say for admission into education institution. So now the purpose changes. Regarding Article 15, the purpose क्या है? Admission into educational institutions. Admission कहाँ करना है? तो educational institutions में करना है. ठीक है? Clear? Yeah, by first CA, 15.4 was added. Correct. Are you so far following this whole idea of reservation? Two questions I'll ask you. Now you are saying that for this reasonable classification, you have categorized into these different categories. I am asking you a rather different question. Can we categorize people either solely on economic criteria? Can we categorize people solely on economic criteria or solely on the basis of their caste? कौन सा? Which one can we categorize on? So now we come to the kind of category. Reasonable classification based on what? किस basis पे हम reasonable classification करेंगे? Salary के basis पे करेंगे, caste के basis पे करेंगे, कुछ और basis पे करेंगे, someone has a पक्का household or not, उस basis पे करेंगे, किस basis पे करेंगे? है ना? All these questions arises. That let's say you are providing reservation, so what is the criteria? Now just look at the dichotomy here. Let's say if you provide reservation on grounds of religion, suppose करिए आप reservation दे रहे हो on grounds of religion, do you think this will violate directly Article 15? Because it says that there cannot be any discrimination on grounds of religion. You understand now? All these issues arose before the Supreme Court. ठीक है? Okay, Krishna? I think those students are not there. They are actually missing one of the most important discussion today. Tell them that this is what we discussed. Krishna, are you following so far? अभी तक आप follow कर रहे हो? Okay. So now my question is that the reservation which is to be provided, or this reasonable classification which is to be done, it is to be done on what basis or what criteria? can we say that the criteria can be solely based on caste? Can we say that the criteria can be solely based on economic criteria, or can we say the criteria can be solely, let's say, based on religion? Can we say this? No, we cannot. And here also there were certain discrepancies initially in terms of decisions of the court. So the court initially said that, see, only on the basis of caste you cannot do. There has to be a mix of caste and economic criteria or occupational aspects. Let's say some particular community is doing a particular occupation ever since for certain centuries, and because of that they are considered to be backward. So I'll ask you this, Krishna, in OBC, what is the full form of OBC? Other backward caste or other backward class? Is it other backward caste or other backward class? क्या है? गलती मत करना एग्जाम में. It is class. Go through article. We'll go through. Don't worry. Abhi tak, are you following so far? Can we give solely a reservation on the basis of religion? No. Can we solely give on the basis of economic criteria? Earlier no, now yes, because of this. Earlier it was no, but now it is yes. This no has now converted into yes. According to previous Supreme Court judgments, you could not have given reservation solely on the basis of economic criteria. But can you give it now? Yes, based on the Constitution 103rd Amendment with respect to EWS. Krishna, following so far? Perfect. Now, after reasonable classification, the court also added another element with respect to Article 14 to test whether any law is violative of Article 14 or not. And this test was referred as the arbitrary test. So whatever reasonable classification was done, it was also to be seen that whether this classification, let's say categorization into all these categories, is it creating an arbitrary decision making process, or is it violating equality considering the arbitrariness? This aspect was highlighted in EP Roypa case. So EP Roypa case says that adherence to principles of supremacy of the law, equality before the law, account all of these, fairness in the application of law, and basically overall, for the first time in EP Roypa case, it was the classification or reasonable classification. Another element was added, the test of arbitrariness. So let's look into the test of reasonable classification. So in this particular case, it says equality is a basic feature of the Constitution of India, and any treatment of equals unequally or unequals as equals will be violation of the basic structure of the Constitution. Now it is saying that EPL, equal protection of the law, is also a basic structure of the Constitution. It is also a basic structure of the Constitution. So it says, while Article 14 forbids class legislation, it does not forbid reasonable classification of persons, objects and transactions by legislature for the purpose of achieving specific ends. So if the objective which is to be achieved is reasonable, rational, then reasonable classification is allowed. However, classification cannot be arbitrary, artificial or evasive. That is just for the sake of it. Any classification must always rest upon some real and substantial distinction, bearing a just and reasonable relation to the object sought to be achieved by the legislature. So another point added into reasonable classification was arbitrariness. So Article 14 can also be judged, or any decision of the government can also be judged on the grounds whether it is arbitrary or not. How can we say it is arbitrary? Because it is not looking into the consideration of certain group of people. So regarding doctrine of classification, it says classification to be reasonable must fulfill the two conditions. Classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group. Let's say if you are categorizing members of EWS and then you are leaving other members, is categorizing of member of EWS is a correct idea along with leaving other members? It's not only you are putting together certain group of certain category of people, but also that you are leaving someone else's behind. And the differentia must have a rational relation to the object which that particular classification seeks to achieve. In this particular case, Ramakrishna Dalmia versus Justice Tendulkar, it says Supreme Court provides for classification test as it permits the state to make differential classification of subjects provided that the classification is founded on intelligible differentia, that is, objects within the class are clearly distinguishable from those that are outside, and has a rational nexus with the objective sought to be achieved by such classification. Hence, purpose of classification should be rational, and the purpose of classification must seeks to achieve the purpose which seeks to be achieved. Now in EP Roypa case, it established the new doctrine or the arbitrariness test propounded by Justice Bhagwati. The test postulates that equality envisaged by Article 14 includes a guarantee against arbitrariness in state actions. Then can we say, Krishna, by highlighting element of arbitrariness, did Justice Bhagwati incorporated the principles of natural justice under Article 14? Can we say that? Yes, what do you think? Can we say that through this judgment, which added the arbitrariness test, in a way it also incorporated principles of natural justice within Article 14? Can we say that? Yes, no, nothing? Yes, Krishna, what do you think? Okay. So overall, court held equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed, cabined or confined with traditional and doctrinal limits. And from a positivist point of view, equality is antithesis to arbitrariness. So both operates on opposite ends. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law and the other to whims and caprice or fancies of an absolute monarch. Where an act is arbitrary, it is implicit in it that it is unequal, both according to political logic and constitutional law, and is therefore violative of Article 14. So this is your arbitrariness test as highlighted under EP Roypa case. Clear? So Article 14 is to be seen from two perspectives: equality before the law and equal protection of the law, and the classification which is to be done under equal protection of the law must be reasonable. The objective must have a rational nexus with the objective which is sought to be achieved, and EP Roypa judgment added the third element, that is, those classification can also be validated or tested on grounds of the fact whether they are arbitrary or not. ठीक है? Krishna, is equality before the law and equal protection of the law clear to you now? Perfect. Another provision of UDHR, Article 9, no one shall be subjected to arbitrary arrest, detention or exile. Now this comes later when we will deal with Article 21 and 22. Okay, rule of law. This is World Justice Project, I think, which we discussed yesterday also. So it says the rule of law is a durable system of laws, institution, norms and community commitment that delivers 4 universal principles. What are these? Accountability. The government as well as private actors are accountable under the law. Second, open government, meaning the processes by which the law is adopted, administered, adjudicated and enforced are accessible, fair and efficient. Just an example, let's say you cannot read Constitution of India. You are not allowed to read Constitution of India. You are not allowed to read Supreme Court judgments. You are not allowed to read the various legislations passed by the government. How will you frame an opinion? How will you know what's going on with the government? Do you think that's a fair aspect of governance? Yes, Krishna? Third is just law. Law is clear, publicized and stable and is applied evenly. It ensures human rights as well as property, contract and procedural rights. And fourth, accessible and impartial justice. Justice is delivered timely by competent, ethical and independent representatives and neutrals who are accessible, have adequate resources and reflect the makeup of communities they serve. So these are the 4 important highlights of this rule of law index created by World Justice Project. Now there are certain exceptions to equality, as I think you have earlier pointed out. Every person is not equal under the Constitution, and there are certain exceptions carved out for certain special people such as President of India and Governor of the states, right? So it says the President of India and Governor of states enjoy the following immunities under Article 361. What are these? President or the Governor is not answerable to any court for the exercise and performance of powers and duties of their office. No criminal proceeding shall be instituted or continued against the President or the Governor in any court during his term of office. No process for the arrest or imprisonment of the President or the Governor shall be issued from any court during his term of office. So till the time they occupy office, no criminal case can be initiated against them. And no civil proceedings against the President or Governor shall be instituted during their term of office in any court in respect of any act done by him in his personal capacity, whether before or after he entered upon his office, until expiration of 2 months next after notice has been delivered to him. So there are certain exceptions with respect to civil proceedings, but the point is that some exceptions have been carved out for President and Governor, and Article 14 does not apply to them exactly because of Article 361. Another exceptions to equality are Article 361A. No person shall be liable to any civil or criminal proceedings in any court in respect of publications in a newspaper of a substantially true report of any proceedings of either house of the Parliament. Now, this is with respect to parliamentary privileges. Have you heard about this? Parliamentary privileges. Krishna? Okay, so it simply means that MPs, MLAs enjoys freedom of speech, freedom of speech, expression. Expression here refers to laying down any reports or presenting any reports. Speech, so I am sure you understand. And also they have a freedom with respect to vote. So these are the 3 freedoms which are generally given as a part of parliamentary privileges under the Constitution. Okay? another issue is, other than that, that whatever proceedings of the parliament are happening, let's say जो भी parliamentary proceedings हो रहा है, proceedings of parliament is taking place, the question is, can these proceedings of the parliament, can they be published? Let's say the prime minister and the leader of opposition confronted each other in Lok Sabha. Can this be published tomorrow in Times of India or in the Hindu or any other? Or can any author write a critical analysis on this issue? And let's say if an author writes and puts a very critical view of the working of the government based on the parliamentary proceedings, can that author be arrested? Can that author who puts a critical view of parliamentary proceedings, can he be arrested? Can he or she be arrested? Yes, please. Krishna, can he be arrested? Let's say tomorrow Shashi Tharoor writes a very critical article against the government, or any member of the ruling government, ruling party writes a very critical view of the opposition. Either ways, can either of them file a case of defamation in the Supreme Court? What do you think? So, for these articles published with respect to the proceedings of Parliament, and a protection has been provided under Article 361A, added by Constitution 44th Amendment. Added by Constitution 44th Amendment. It simply says that if the parliamentary proceedings are true, then no case can be filed against them. What sort of case? Any criminal case or case of breach of privilege. Basically, breach of privilege notice is generally sent by the speaker or the chairman. This notice is sent by the speaker or the chairman. So Article 361A in that sense grant this immunity if the publication is true and without any bad faith, without any ill faith. Except secret settings. Correct. Absolutely true. Except secret settings. Or any confidential setting which is not to be published. Nice. ठीक है, this point clear? कृष्णा, ये याद रखना पार्लियामेंट्री प्रिविलेजेस में 361A. Next it says that, so ये दोनों article 105 and 194 basically talks about parliamentary privileges. Article 31C is an exception to Article 14. This though we have already seen that if any law is made by the government to implement directive principles under 39B and 39C, then it cannot be challenged on grounds of violation of Article 14 and 19. ठीक है? Yeah, absolutely correct. By 25th Constitution Amendment. अब आप लोग सब लोग सही जवाब दे रहे हो. Krishna, you feel more confident after these 10-11 classes for polity? Have I given you some added information? So, and diplomatic immunity is given to foreign officials. Judgments and articles remembering problems, don't worry. अभी अभी डोंट वरी अबाउट दैट. मुझे बस ये बताओ, yesterday we discussed about state. Which article? चलो let's play this quiz. State which article? 12. तो याद तो है. Laws on which there is judicial review for both pre-constitutional law and post-constitutional law. Which article? Which article? 13. सब तो याद है, और क्या प्रॉब्लम है आपको? Which problem do you have? Internal reorganization of states. Internal reorganization of states. Which article? Correct. 7CA. But which article? Between 1, 2, 3. 3. Admission of new states. Article 2. Admission of new state. Article 2. And where is the definition of India given? Whereas India been defined under the constitution. Which article? India, that is Bharat. Perfect. तो क्या प्रॉब्लम क्या है आपको? सब तो याद है. सिटीजनशिप छोड़ दो, वो उतना पूछा भी नहीं जाता है. जो इंपॉर्टेंट है वो यही है, नथिंग मोर देन दैट. जजमेंट्स यू विल अंडरस्टैंड. Okay, tell me, basic structure doctrine so far? Basic structure doctrine. केशवानंद भारती, सही है. Which judgment said that judicial there is the balance between fundamental rights and directive principles of state policy is also, this balance is also a basic structure. ये कौन सा जजमेंट बोला? मिनर्वा मिल्स. परफेक्ट. तो लैंडमार्क जजमेंट, सी यू ओनली नीड टू रिमेंबर द लैंडमार्क जजमेंट्स. नाउ विच जजमेंट सेड that even addition of laws under 9 schedule will be subject to judicial review. Which judgment said? Addition of laws under 9 schedule will be subject to judicial review, but after 24th April 1973, क्योंकि इसी दिन केशव नंदा भारती का जजमेंट दिया गया. Which judgment? These all are previous judgments. कोयलो, IR कोयलो. सब तो याद है. इसलिए याद है because you have understood in a very elaborative manner. And which judgment has suggested that Article 14, मतलब Article 14 में along with reasonable test के साथ arbitrariness का भी टेस्ट होगा. ये किसने बोला? Which judgment? We just saw this one. Arbitrariness test will also take place. Which judgment has highlighted? EP Royappa वर्सेस तमिलनाडु. ठीक है, अभी we just saw. Now let's move to, अब पढ़ते हैं और judgments with respect to reservation. I think your concepts are absolutely clear. No doubt here. These are the landmark judgments. This is what you need to know. You don't need to remember everything. At least you have written whatever I discussed in the lectures, previous lectures. I think you have been attending these classes regularly. So I'll ask you again, are you feeling more comfortable with polity now? Are you concepts clear हो रहा है, चीजें और clarity से समझ में आ रही है? Good. That's the idea. That you just don't read the statements, you just don't mug up कि just because लिखा हुआ है Government of India Act 1935 provided for provincial autonomy and abolished hierarchy. But we never understood what is diarchy and what is provincial autonomy. Now you know that the Government of India Act 1919 provided diarchy in the states, and Government of India Act 1935 tried to provide diarchy at the center. Okay. Not able to catch up, Krishna? Don't worry. Is this part clear? ये वाला? अच्छा, एक और चीज समझ लो, क्योंकि we have discussed Constitution 25th Amendment. इसी से रिलेटेड है आर्टिकल 39B. Okay. Now I have told you under Article 39B, government used to nationalize property. Government used to nationalize property. But can all property be nationalized? Can all private property be nationalized? Can all private property be nationalized? No, all property cannot be nationalized. And this has been highlighted in a recent judgment of Maharashtra Properties Owner Association, a properties association versus State of Maharashtra. We will look at it separately, but just remember as of now, since we have discussed about Constitution 25th Amendment, बस ये याद रख लो कि all private property cannot be nationalized. And this has been a very significant judgment of late. It's a very important judgment. So let's understand about reservation. Okay. रिजर्वेशन के साथ कुछ इश्यूज हुआ शुरू में. इनिशियली आर्टिकल 15 clause 4 was added through Constitution First Amendment. Just write these down. Article 15 clause 5 was added by Constitution 93rd Amendment. Article 15 clause 6 added by Constitution 103rd Amendment. Okay. Article 16(4)(a) was added by Constitution 77th Amendment, and Article 16 clause 6 added by Constitution 103rd Amendment. Write this down first, all of it. Perfect. With reservation also came the same problem. Implementation of reservation was essentially a welfare goal. It was essentially a welfare approach, and in that sense, welfare goal or welfare objective. So the problem with respect to reservation which actually became was that it became acted contrary to Article 14 and 15. And this welfare goal for reservation, the government highlighted that it was trying to implement provisions of Article 46, which itself was part of DPSP. And because of provision of reservation, initially what it encountered, the problem which it encountered was that it ended up violating both Article 14 and 15. That was the initial understanding, that reservation violated Article 14 and 15, and hence to accommodate reservation, the Supreme Court came up with an idea that this reservation acts is an exception to equality. So this was the ideological problem. The ideological problem with reservation, that government implemented reservation or various schemes for reservation. अब government कहाँ implement करता था? तो let's say provided reservation in colleges, universities. Major problem was with respect to education institutions. Why? Because 16 clause 4 was itself part of the main constitution, original constitution, but 15(4) it was added later. Yes, correct. In N.M. Thomas case, it was this idea of exception to equality got converted into extension of an equality code. See, now you also remember the case. Okay? So Krishna, the idea is not to remember the case, idea is to remember the concepts. The moment you remember the concepts, revise करोगे तो case खुद ब खुद याद आ जाएगा. So what's the idea? Not to mug up the case. Case नहीं याद करना है, concept समझना है. केशव नंदा भारती तो चलो सबको याद है, but Minerva Mills नहीं समझना है. समझना है problem or the issue of balance between fundamental rights and DPSP. So this was one aspect, which we can say ideological aspect. तो चलो ideological aspect भी clear हो गया. Second problem which arose was with respect to quantum, that is quantum of reservation. How much reservation was needed? कितना reservation चाहिए? ये कौन डिसाइड करेगा? रिजर्वेशन तक तो ठीक था, ये ठीक है, चलो पहले एक्सेप्शन था, बाद में इक्वालिटी बन गया, बट कितना रिजर्वेशन दिया जाए? आज भी यही मुद्दा है. टुडे ऑल्सो दिस इशू रिमेन्स द सेम, and it's actually a genuine issue, that how much reservation needs to be given and to whom. Okay, for this initially the court came up with this idea that, see, you cannot cross the limit of 50%. जिसको मन चाहे रिजर्वेशन देना है दो, इससे ज़्यादा नहीं दे सकते. अब 50% के अंदर में आपको जो करना है करिए, आपको 50% सीट्स ओपन कैटेगरी में रखना ही पड़ेगा. सो 50% सीट्स आर रिजर्व्ड and the remaining 50% are open to the general category. But Krishna, what is the present percentage which remains for the open category? It's only 40%, because the extra 10% is provided to EWS. Okay. Or this is a general understanding, and subsequent case also end up saying this only. So this is the second criteria. First understanding is ideology. Ideology wise क्या है final answer? Reservation is an part of equality code. Write this. On ideological level, reservation is a part of equality code and can be found implicit under Article 14, 15 and 16. Can be found implicit under Article 14, 15 and 16. Which case gave this idea? N.M. Thomas. So ideologically, reservation is part of equality code, is not an exception to equality, or no more an exception to equality. Earlier it was considered as an exception to equality. So ideologically this is the situation. Second, in terms of quantum, कितना reservation देना है? So आज भी the quantum is fixed at 50%. You cannot go beyond 50%. And this applies not only, write this, ये लिख लो. This applies not only with reservation. This applies not only with reservation under Article 15(4) and 16(4), but also reservation for local bodies. But also reservation for local bodies. Just write this. Article 243 clause D subclause 6 and Article 243 clause D, sorry, clause T, T for train, T subclause 6. यहाँ पे भी यही बोला गया, क्वांटम कितना होगा? 50% होगा. Second point. Third point, basis of reservation. Basis of reservation. Just write. Generally, it's a mix of caste and class. Generally, it's a mix of caste and class. However, reservation is not given solely on the basis of caste. Reservation is not given solely on the basis of caste. Reservation not given solely on basis of caste. And recently, reservation solely on the basis of class has been provided under Constitution 103rd Amendment. On the basis of class, reservation provided under Constitution 103rd Amendment to EWS. Okay, to EWS. कोई और चीज़ है जो छूटता है रिजर्वेशन में? सोचो. CA? What CA? What's that? Right, fourth point. In educational institutions, reservation is given at graduate as well as postgraduate level. reservation is given at graduate and postgraduate level. और क्या बचा? Write the fifth point. Don't have space here. I'll remove this. Fifth point, reservation. Fifth है ना? हाँ. Allowed in promotion. Reservation allowed in promotion. Sixth, subcategorization allowed, meaning, for example, in OBC there is a creamy layer. Similarly, recently in Devinder Singh versus State of Punjab, Supreme Court has held that even this subcategorization can also be done with respect to members of scheduled caste. So subcategorization allowed for OBC and scheduled caste. I think more or less we have covered the idea of reservation. Which one, Krishna? Constitution amendment? No, all of them. So initially I have told you na, the constitution amendment regarding 15 and 16. We need to discuss this, don't worry, it's a big chapter. I am just giving you the backdrop or the points which we are about to discuss. I just highlighted you those points so that it becomes easy जब आप उन provisions को पढ़ोगे. Krishna, just tell me this. Let's say a question is asked on reservation. At least you will be able to highlight these 6 points now. Let's say you don't remember the article. कुछ भी नहीं याद है कि कहाँ क्या लिखा है, 15 में है, 16 में है. You don't remember much. But at least can you give these 5 or 6 important points? Have you written this in your notebook? In your copy? Please write. Good. If you want, take a screenshot because I think it will go away. I'm removing this. All right. And quantum percentage. So the basis of reservation, as I've told you, was highlighted in Article 46, which says that state shall promote with special care educational and economic interest of the weaker section of the people, in particular of scheduled caste, scheduled tribes, and shall protect them from social injustice and all forms of exploitation. So this was given as the basis of reservation initially by the government. फिर आता है Article 19 also comes into picture. Now see, when we talk about reservation, then educational institution also gets covered under this part, because whoever are running educational institution, they have a right to practice any profession, carry any occupation, trade or business. And here particularly the issue is with respect to those trust or society running minority educational institutions, particularly, or even private educational institutions, because most of the colleges or universities are registered as a Society Registration Act, and hence running a school or a college, hence running a school or college is also a fundamental right under Article 19(1). कौन सा है? G. And that is right to practice any profession, to carry on any occupation, trade or business. Okay. Now this part we will cover more when we will discuss Article 29 and 30. Yes, Krishna. Yes, please.
Instead of writing these articles, can we write the 6 points if we did not remember it?
Instead of writing
the 6 articles, if we did not remember in exam, can we write the points?
Which points?
The 6 points now set up together.
We'll come to that. We'll come to that. So now we'll discuss each of those points. You have written those points, right?
Yes, sir.
Okay. So you want me to explore those points?
If you did not remember in exam, these points, these article numbers, 15(4), 15(5).
We'll come to that. We'll come to that. Don't worry. Don't worry. We'll come to that. See, I'll discuss each of them. So this is Article 15. Article 15 starts with prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. So basically on these grounds you cannot discriminate, correct? So it says state shall not discriminate against any citizen. So this right is granted to citizen on grounds only of these, and no citizen shall on grounds only of religion, race, caste, sex, place of birth or any of them shall be subject to any disability, liability, restriction or condition regarding access to any shops, public restaurants, hotels and places of public entertainment. So this ground cannot act as a ground of discrimination by restricting access of people to shops, restaurants, hotels or places of public entertainment. And people can also not be restricted with respect to use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. And then it says nothing in this article shall prevent the state from making any special provision for women and children. So special provision can also be made with respect to women and children under Article 15 in that regard. So let's say, my question to you is, Krishna, let's say the government makes certain special provision with respect to women and children, don't you think then in this regard it's a violation of this part? Particularly making a law particularly for a particular gender? Isn't then that a violation? Correct. It's not a violation. Why? Because through this is an example of horizontal reservation. We'll discuss about horizontal and vertical reservation. So reservation is created within the part of the reservation, that is horizontal reservation. Now come to Article 15 Clause 4, the most important article which we were discussing so far. So it says nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. So just write that under Article 15(4), under Article 15 Clause 4, special provisions can be made, special provisions can be made for the advancement of any socially and educationally backward class of citizens. Socially and educationally backward classes of citizens. See, the word is classes of citizens, not caste of citizens. Socially and educationally backward classes of citizens, or for the scheduled caste and scheduled tribes, or for the scheduled caste and scheduled tribes. So what sort of backwardness has been provided under Article 15 Clause 4? It is socially and educationally backward classes of citizens, or for scheduled caste and scheduled tribe. Clear? And of course this was added by Constitution First Amendment. Krishna, is this clear? Yes, Krishna. Yes. I did not get you.
Regulation topic is starting with 5 articles, 15.4, 15.5, 15.6.
Yeah.
16.4, 16.6.
Yeah. So this is
We
15.
need to remember caution. We need to remember the amendments.
Yes. 15.4 is the most important. 15.4 is the most important.
Okay, for first one, for other no need to remember. I have to remember 7 also.
Sorry, I'm not able to understand what you're saying.
For other article numbers, no need to remember Constitution Amendment numbers.
See, there are few, particularly for reservation, there are few important these provisions which we must understand. More than remembering the number 15.4 or 15.5, let's understand what is provided in terms of reservation. So please understand it like this. For example, if I say the reservation, amendment numbers are important, Krishna. Questions are asked on that. You have to remember that. Okay, another important point is regarding this. So under Article 15, the word used is socially and educationally backward. Okay, so it fixes the criteria of backwardness, educationally backward class of citizens. And under Article 16, the word used is any backward class of citizen. Any backward class of citizen. Is there any difference between the type of backwardness provided under Article 15 and 16? Do you think there is any difference? Which is more broader in terms of calculating or finding out backwardness of a class of citizen? No, 16 is more broad. This is a much more broader concept. Why? Because it does not limit the idea of backwardness. It simply says any backward class of citizen. Could be anything. Not merely socially and educationally backward, but could be any other aspects of backwardness also. So between the type of backwardness mentioned in Article 15 and 16, which is more backward or which is broader in terms of calculating or finding out the backwardness, it is Article 16. Just remember this. And Article 15 is for reservation for educational institutions, and of course Article 16 is for public services or public employment, the word used. Okay. 15.4, the provision 15.4 added by Constitution First Amendment. But 16.4 was already there. It was not added by any amendment. It was already there in the Constitution. Yes, correct. Even covers economic backwardness or any other criteria. Let's say backwardness on the basis of who is residing outside a particular village, or who, let's say backwardness on the basis that's who is not given access to a public place. Could be any criteria. Just remember this. Shall I remove this? So 15.4 is clear. Let's go through 15.5 first. 15.5 says that nothing in, नहीं, पहले 16.4 देख लेते हैं. 16 देखते हैं because both needs to be compared. 15.5 will deal later. 16 says equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Now it says no citizen shall on grounds only of religion, race, caste, sex, place of birth, residence or any of them. Now see, the grounds mentioned under Article 16 Clause 2 is also more as compared to the grounds mentioned under Article 15. It only talks about religion, race, caste, sex, place of birth or any of them. Clear? The grounds mentioned under Article 15 is lesser. That is, kitna hai ground? Religion 1, 2, 3, 4, 5 or any of them. At least 5. Specific grounds are 5 under 15. And in 16, let's see, 1, 2, 3, 4, 5, 6, 7. So extra क्या क्या है यहाँ पे? Descent, place of birth and resident. नहीं, descent and residence. Clear? So grounds of distinction under Article 16 is also wider or is also more. Or any of them be ineligible for or discriminated against in respect of any employment under office or state. ठीक है? Now Article 16(4) says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or post in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. ठीक है? Clear? The difference you understand? Under 15(4) it is socially and educationally backward class of citizens. So the criteria is defined either socially or educationally under 15. Under 16 there is no criteria, any backward class of citizen. It's up to the government to decide what sort of backwardness they are talking about. Okay? Alright. Now let's go to Article 15 Clause 5. This one says that nothing in this article or in Article 19 shall prevent the state from making any special provisions by law for advancement of again any socially and educationally backward classes of citizens or the scheduled castes or scheduled tribes insofar as such special provisions relate to their admission to educational institutions including private education institutions. So it is giving reservation to members of socially and educationally backward classes of citizens and members of scheduled caste and scheduled tribe regarding what? Regarding admission to education institution including private educational institution. So even in private educational institution reservation is to be provided, whether aided or unaided by the state other than the minority education institutions. Now this means actually a lot of things. First of all, reservation किसको दिया गया? Socially and educationally backward class of citizens plus scheduled caste and or scheduled tribe. So these are the criteria or category of people to whom reservation is provided. For what purpose? For reservation for admission to educational institution. अब कैसा कैसा institution includes? Of course, government institution, private institution, aided or unaided is whether aided or unaided by the state. So such private institutions, whether they are helped by the, provided finance by the state or aided by the state or unaided by the state. However, this reservation shall not apply reservation to this reservation shall not apply to minority education institutions. Is it clear? So minority education institutions need not provide reservation to members of socially educationally backward class or scheduled caste or scheduled tribe, and hence they can set up their own reservation for members belonging to minority class. That's why this provision is important. Provision समझ लो, amendment बाद में revise करते करते भी याद हो जाता है. Provision is more important. Who are minority? This is a very valid question. That has to be depend on basically this education institution. Minority refers to the 6 religion which are categorized as minority religion. So there are different types of minorities to be understood with respect to right to religion and cultural and educational rights. So the concept of minority is very broad, or rather different for different perspective. But in this regard, minority in terms of cultural or religious. हाँ, only for public employment, not employment. Private employment में नहीं है reservation. बहुत बार ये मुद्दा उठता है. Many times this topic is raised. Yes, only government employment. Another important thing, so minority institutions, first point, whatever they are we'll discuss later when we'll take up the chapter on educational and minority rights. As of now, just remember, minority education institutions, if they want, they cannot provide reservation to SEBC, socially educationally backward class of citizen, scheduled caste and scheduled tribe. If they provide, fine, no problem. But if they do not provide, then there is, as such, there is no constitutional problem. But even for minority education institution, let's say a minority education institution is for Muslims or for Jains, जिनके लिए भी है. Again, the percent of reservation cannot go beyond 50%. So even a minority education institution does not mean कि 100% बच्चे ही minority के ही रहेंगे. It doesn't mean that. It will be open mixed institution, but yes, 50% reservation can be fixed for minority institutes, for children belonging to minority class or that group of minority. So 50% criteria is fixed everywhere. Yeah, sort of. So far, is it clear? I know, Krishna, this is one of the most complex and technical topics which we are discussing right now. I must tell you this. It's not that easy to understand. It's not that easy. So let's take slowly. हाँ, थोड़ा logic भी लगा के you can definitely solve the questions. EWS, let's बाद में उसको देखते हैं. हालांकि EWS में ऐसा कुछ है नहीं. It says simply that government can make special provision for advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and 5. So the point is, whatever is mentioned under clause 5 and clause 4, the categories with respect to reservation, it is a category other than that. Why? Because it's a category based on economically weaker section. So EWS reservation, in fact, just write this. The criteria for EWS, that's why it's called EWS. It is based on economically weaker sections, or reservation is provided for the advancement of any economically weaker sections of citizens, which is decided according to the government. And where this is provided, EWS is provided, they are provided to their admission to education institutions, including private educational institutions, whether aided or unaided by the state, other than the minority education institutions. यहाँ पे भी same criteria, that EWS cannot be applied to minority educational institutions. And how much will be the EWS reservation? Would be in addition to the existing reservations and subject to a maximum of 10% of the total seats of each category. In short, it will be in addition of this. So whatever reservation has been provided for other backward class, scheduled caste and scheduled tribe is within 50%, and the reservation for EWS is further 10%. Yeah, 50 for others and 10 for EWS. Perfect. Do you know how much for others particularly? %, scheduled caste, 15%, scheduled tribe, 7.5%. How much is total? Total comes to 49.5%. So this is your total reservation within 50% category, and on this add EWS, which is 10%. So total comes to this plus 10% is equal to 59.5%. This is the reservation currently. Huh, 40.5% for general. Yeah. Okay. Now come to another important point. See this. So now let's come to one point which you wrote regarding reservation in promotion. So can reservation be also given in promotion? So on this note, it says 16(4)(a) says that nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of post in the services under the state in favor of the scheduled caste and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. Now let's say in the year 1990, 100 people were recruited to a service. Obviously reservation was also applied, and of this 100 people, 15 were from scheduled caste and let's say 7 were from scheduled tribe. And after 10 years, or let's say after 15 years, in the year 2005, obviously all of these members would have given promotion, but let's say they were given promotion to the level of joint secretary. But it was observed that at the level of joint secretary, the number of representation of members of scheduled caste and scheduled tribe was very low. Hence, more chance was given also to people belonging to scheduled caste and scheduled tribe to be appointed as joint secretary even at the cost of some of the general candidates. Now this created a lot of controversy, I'm sure you understand, and that led to a very important judgment of M. Nagraj. But uske pehle there are other judgments. Have you heard about the judgment of Indira Sawhney? Krishna? Okay. Are you aware about the aspects of Indira Sawhney judgment? This we have already discussed. So let's understand few case laws which are actually very important. Now, State of Madras versus Champakam Dorairajan, this actually deals with Article 15 and the understanding initially that reservation was an exception. Now, let's understand actually हुआ क्या यहाँ पे. In this, Madras government had reserved seats in state medical and engineering colleges for different communities in certain proportions on the basis of religion, race and caste. So what was the basis of reservation of seats in education institution? Religion, race and caste. State defended the law on the ground that it was enacted with a view to promote social justice, to implement Article 46, that is to ensure social and economic justice for the weaker section of the society. So government said ki see, we intend to implement Article 46 and that's why we are providing reservation to education institutions on this criteria. Supreme Court held the law void as in illegal. Supreme Court बोला कि ये जो आपने reservation दिया, the reservation which you provided is illegal because it classified students on the basis of caste and religion irrespective of merit. So another issue arose that can we look away the concept of merit and thus provide reservation? The court observed that reserving seats in education institutions solely on the basis of caste and religion is unconstitutional. Supreme Court struck down the reservation policy as it violated individuals' fundamental rights upon conjoint reading of Article 15(1) and 29(2). Basically, it said that it is void, it is illegal. Now look into this point. I am sure you will correlate. Court considered the constitution as caste blind. Krishna, can we say that in this judgment, the court gave more primacy to equality before the law than equal protection of the laws? Equality before the law, है ना? Negative aspect को, the negative aspect was given more primacy in this case. So the court said that the constitution is caste blind because it required that except where specifically provided otherwise, government must treat citizens as individuals and not as members of particular race or community or religion. And this case established that directive principles of state policy cannot override fundamental rights. That was another reason given by court. You see, you are saying, the government is saying that you want to implement Article 46, which is a part of DPSP, but DPSP is not justiciable. And you cannot make a law which comes at a cost of fundamental rights of citizens, particularly Article 15 and 14. So the court said, ki no, your law is wrong. It is in violation of Article 15 and 14. And here the court gave more primacy to equality before the law, the British concept, not the American concept. Next case, M.R. Balaji versus State of Mysore. Mysore government issued an order under Article 15(4) reserving seats in medical and engineering college in state as follows. Backward classes 28%, more backward classes 20%, scheduled caste 15%. How much is the total? 48, 58, 63%. And another aspect which highlighted here is that it subcategorized reservation. Subcategorized. That is, within a backward class, it created a more backward class. Within a backward class, it tried to create a more backward class of citizens. So it says, thus 68% of seats available in the colleges were reserved and only 32% was made available to the merit pool. And the validity of the order was challenged by candidates who had secured more marks than those admitted under the reservation. What did the court say? Court said same thing what was highlighted in previous case. Supreme Court capped the reservation at a maximum of 50%. See this. So it was in, for the first time in MR Balaji, this idea of capping of reservation at 50% came into picture. On the ground that exceptions, another thing was added, that reservation is an exception. That exceptions, namely Article 15.4 and 16.4, could not swallow up the rule of equality and non-discrimination. Krishna, are you following this line of the statement of the judgment? That Supreme Court capped the reservation at 50% on the ground that exceptions, namely 15.4 and 16.4, that is reservation provided under 15.4 and 16.4, could not swallow up the rule of equality. Yes, and Supreme Court held that Article 15.4 does not provide for classification between backward and more backward class of citizens. So Supreme Court said that see, subcategorization is not allowed. In MR Balaji, Supreme Court said subcategorization not allowed. Court further held that caste cannot be the sole criteria to determine socially and educationally backward classes. Caste cannot be the sole criteria. This we have also discussed initially. And later, reservation under 15.4 should be reasonable and should be applied to defeat and nullify the main rule of equality under Article 51, and should not be applied to defeat, reservation should be reasonable and should not be applied in such a manner to defeat or nullify the main provision of Article 15.1. Is this part clear, Krishna? Because now comes another important judgment, Devdasan versus Union of India. Policy of Balaji judgment was reaffirmed, where court prohibited state from carrying forward unfulfilled vacancies into succeeding recruitment years. So let's say if there was a vacancy, let's say in the year 2010, there were 15 seats for scheduled caste, and in the year 2010 only 10 seats were filled. Only 10 seats were filled. So what was happening in 2011? 15 seats plus the remaining 5 seats were added to the list. This is what was happening. Okay. So it says Supreme Court also declared that more than 50% reservation of post in a single year would be unconstitutional, as it destroys Article 16.1, and in the name of advancement of backward communities, fundamental rights of others cannot be annihilated. So, reiterating the principles of Balaji, court held 16.4 is an exception to Article 16.1, and also did not allow state from carrying forward unfulfilled vacancies into succeeding recruitment years. Okay. Then comes State of Kerala versus NM Thomas. तो इसमें आप बस ऐसे याद रख लो. I think I've written it somewhere. Remember it like this, Krishna, that initially reservation was considered as an exception to equality by these three judgments, Champakam Dorairajan, M.R. Balaji and T. Devdasan. And it was considered as a part of equality or extension of equality code by State of Kerala versus N.M. Thomas. Okay? So these are the four important judgments with respect to the fact whether reservation is an exception to equality or part of equality. Now we will deal with further aspect of subcategorization. Categorization. So did these judgments particularly Balaji, did Balaji allowed for subcategorization? No, correct, did not. Perfect. N.M. Thomas तो देख ही चुके हैं. There was a fundamental shift in understanding as Article 16.4 no longer operates as an exception to 16.1 but a part of it, and allowing the government limited powers to do what it would otherwise be prohibited from doing by virtue of 16.1, because it now exists as one of the methods achieving equality embodied in 16.1. Basically, in simple words, court said ki see, you don't even need 16.4 to provide reservation, since reservation is a part of equality. Hence, this idea can even be found under 16.1 as a part of affirmative action, and also under Article 14, क्योंकि वहाँ तो लिखा ही हुआ है equal protection of the law. So, court ended up saying to that extent that you don't even need 16.4 to give reservation in public employment. Article 14 is good enough, even 16.1 is good enough. So, the court ended up saying that Article 16.1, being a facet of doctrine of equality enshrined in Article 14, permits reasonable classification as well, and hence it was permissible to give preferential treatment to scheduled caste under Article 16.1 outside 16.4. In short, हो गया क्या? Supreme Court said Article 14 is the bigger umbrella, and इसी के अंदर smaller umbrellas fit होते हैं, कोई भी हो, चाहे वो Article 15 हो जाए, Article 16 हो जाए, और Article 29 हो जाए. We will talk about this later. Article 14 is the larger umbrella, and within all of these are part of this Article 14. Krishna, doubts? Please ask. Do you agree Article 14 is the larger umbrella? And hence, since Article 14 is the larger umbrella, so tomorrow if reservation is provided, it can be checked that whether reservation is arbitrary or not. It can be checked that whatever the grounds of qualifications have been made for reservation, whatever the grounds of classification has been made for reservation, whether there is a rational nexus, with the object to be achieved. Object to be achieved. All of this now can be tested because now reservation is considered a part of Article 14. Correct, equal protection of the law. I think now you have absolute clarity on equal protection of the law. Now comes Indira Sawhney judgment. Now in this, actually what had happened was that there was a political backdrop to this. The political backdrop was Mandal Commission, and Mandal Commission had suggested reservation to OBC, and hence the government gave reservation of 27% to OBCs, and this further led to huge protest in the country, right? In the backdrop of this political scenario, this judgment was given. So it says in this judgment that majority of 9-judge bench upheld reservation of 27% in favor of backward classes, and further subdivision of more backward class within the backward classes who were given preference. So this judgment gave two important things. Indira Sawhney said two important things, that subcategorization for OBC into more backward and less backward is allowed. More backward and less backward this is allowed, and this was considered as the creamy layer. So subcategorization for OBC was allowed, but Indira Sawhney said that subcategorization for SC is not allowed. As of now, just remember this: subcategorization for scheduled caste not allowed. This is what Indira Sawhney judgment said. Another important point which this judgment highlighted was that this reservation also provided a specific reservation on economic criteria. On economic criteria. This was declared to be unconstitutional. Court said that you cannot provide reservation only on economic criteria, and that's why the Constitution 103rd Amendment for EWS was challenged because of the judgment in Indira Sawhney. Okay, these are the three important points with respect to Indira Sawhney judgment. Clear, Krishna? And this is exactly what was highlighted by the courts. So court said that court, however, struck down the reservation of 10% in favor of other economically backward classes. Excuse me. So it says the test or requirement of social and educational backwardness cannot be applied to scheduled caste and scheduled tribes who fall within the expression backward class of citizens. इन्होंने कहा कि see, those who are members of scheduled caste, they are already backward because the member of scheduled caste is prepared through a presidential list under Article 341. So basically, those who are declared as scheduled caste, इनके लिए president एक list निकालते हैं, referred as presidential list, and this presidential list is according to Article 341. So let's say if this is the list and someone's name or someone's communities appear in the list as scheduled caste, this list is state-wise. Court is saying the moment that community comes within this list, it is already backward. It need not prove their backwardness. Okay? And hence it says the test for backwardness, test required for social and educational backwardness cannot be applied to scheduled caste and scheduled tribe because they are already backward. The scheduled caste and scheduled tribe are the most backward among backward classes, and once their name appears in the presidential list under these provisions of the Constitution, they need not prove their backwardness. So who need not prove their backwardness? Scheduled caste and scheduled tribes need not prove their backwardness. Then the advanced section among the OBCs, that is creamy layers, should be excluded from the list of beneficiaries of reservation. Simple. OBC को हटा दिया reservation से because they have achieved the status of a normal citizen. And there shall be no reservation in promotion, and reservation should be confined to initial appointments only. Another very important point, there shall be no reservation in promotion. The court accepted the cap of 50% on reservation, which can be breached only in certain special circumstances. Another important point, पहला 50% rule and दूसरा no reservation in promotion, which was highlighted by Indira Sawhney judgment. After this, the government initiated Constitution 77th Amendment Act and introduced a new article, Article 16(4)(a), obviously, which provided reservation in promotion. It provided reservation in promotion. To whom? To members of scheduled caste and scheduled tribe. Krishna, clear? After Indira Sawhney judgment, government came up with Constitution 77th Amendment, adding Article 16(4)(a). What did it provide? Reservation in promotion for scheduled caste and scheduled tribe. Clear? This was challenged in M. Nagraj. So in M. Nagraj it says constitutional validity of 77th Amendment was challenged, which provided for reservation in promotion along with other amendments on backlog of vacancies. Supreme Court said that this upheld the constitutionality of 77th Amendment and said it is very much valid, कोई problem नहीं है. But it did provide certain criteria to provide those reservations. क्या criteria है देखते हैं. So it says if a state government wishes to make provisions for reservation to members of scheduled caste and scheduled tribe in promotion. So this is, we are talking about reservation in promotion. It says then the state has to collect quantifiable data showing backwardness of the class and inadequacy of representation of that class and maintenance of efficiency. So three things that the state government must show through collection of data that they are not adequately represented, and also that the backwardness of the class needs to be proved. And third, whatever reservation you are giving, it should not hamper administration, efficiency of administration. It should not hamper efficiency of administration. These criteria: backwardness of class, so there is a need for quantifiable data to prove backwardness. Inadequacy of representation needs to be proved, and administrative efficiency need not be compromised. Yes, Krishna. Yes, Krishna. Please speak if possible. Only for SC/ST. Reservation in promotion only for SC/ST. So 16(4)(a) provides reservation in promotion only for SC/ST. Court is saying कि जो भी whichever state governments want to provide reservation in promotion, these are the three things they must do. They must ensure backwardness of their class and collect quantifiable data. They must ensure any inadequacy of representation and administrative efficiency. So, reservation in promotion can be given to whom? Can be given to members of scheduled caste and scheduled tribe. But three criteria have to be fulfilled. Data must be collected. To ensure backwardness. Data must be collected to ensure that a particular cadre of service जहाँ पे आपको reservation देना है, that is inadequately represented. And whatever reservation you give in your promotion, it should not hamper efficiency. It should not hamper efficiency. But overall, the court said that Article 16(4)(a), which provides this reservation in promotion, is constitutionally correct. Clear? It is constitutionally correct. Now there is another judgment, Jarnail Singh, which says that this need not be done because they are already backward. These two are necessary. In Article 335, what does it say? Claims of scheduled caste and scheduled tribe to service and post, that claims of members of scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in making of appointments to services and post in connection with the affairs of the union or of a state. Meaning, simple meaning, that yes, members of scheduled caste and scheduled tribe can be given reservation, no problem, but efficiency of administration should not be compromised. That needs to be taken care of. Now look into this judgment, this question asked in the prelims of 2024. Krishna, I hope you will be able to solve this. Consider the following statements. First, statement 1. Supreme Court of India has held in some judgments that reservation policies made under Article 16(4) of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. See this, directly a question is asked from a constitutional provision and also from understanding of the judgment. Yes, Krishna? Is this correct? Is the first statement correct? Yes, no? See the judgment again. An inadequacy of representation and class and maintenance of efficiency. Administrative efficiency must be maintained according to Article 335. Court is saying that yes, you can give reservation, but administrative efficiency should not be compromised. So yes, it acts as a limitation. इसको ऐसे समझो कि court is saying that you can give reservation. You can give reservation in promotion, no problem. But please ensure that आप जिनको भी reservation दे रहे हो, to whomever you are giving reservation, that should not compromise. That should not compromise efficiency of administration. So can we say that this efficiency of administration is acting as a limitation? And this is provided under Article 335. That yes, you can provide reservation to members of scheduled caste and scheduled tribe. Reservation in promotion can be given, or reservation can be given to members of scheduled caste and scheduled tribe, but efficiency of administration should be maintained, or this should not be compromised. So in a way it is acting as a limitation, right? Read this again, see. Court says that if a state government wishes to make provisions for reservation to SC and STs in promotion, state has to collect quantifiable data showing backwardness of the class and inadequacy of representation and class, and also maintenance of efficiency. So basically it should not be compromised. Yes, please. I'll read that statement again. Supreme Court of India has held in some judgments that reservation policies made under Article 16(4) of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. Is it okay? Correct, absolutely. This statement is correct. Second, Article 335 of the Constitution of India defines the term efficiency of administration. Let's look into 335 again. It simply mentions about efficiency of administration. It does not define it, what it is, what are the parameters, how it will be calculated. It does not define it. It simply says that claims of members of scheduled castes and scheduled tribes with respect to reservation shall be taken into consideration consistently with the maintenance of efficiency of administration in making of appointments to services and posts in connection with affairs of the Union of State. It simply says that, does not define it. Okay? So these type of questions are often asked. So the second statement is incorrect. So which of the following is correct in respect of our statements? Both 1 and 2 are correct? No. Both 1 and 2 are correct? No. Statement 1 is correct, but statement 2 is incorrect. C. Okay. Any doubt? Please ask. Because see, this is a very direct question asked on the topic which we have covered today, and it is based on successive Supreme Court judgments, not just one. It is saying Supreme Court of India has held in some judgments. Questions for practice, you can just write how has the Supreme Court interpreted the concept of reservation under the Constitution of India. How has the Supreme Court interpreted concept of reservation under the Supreme Court of India? And lastly, this judgment was Jarnail Singh versus Lakshmi Narayan. Basically, it just said that M. Nagraj judgment is correct, everything is fine, no problem. It's just that the members of scheduled caste and scheduled tribe need not prove their backwardness, because the moment their name appears in the presidential list, they are considered backward. So it says, court confirmed their findings on 2 grounds: whether state had to collect quantifiable data to show backwardness of members of scheduled caste and scheduled tribe. The answer was yes. And can the concept of creamy layer be applied to the members of scheduled caste and scheduled tribe, as it will amount to subclassification within members of scheduled caste and scheduled tribe? In this judgment, the court said no. But so it says that the highlights of this judgment: there is no need to revisit the judgment of M. Nagraj again, because the previous judgment is correct. States no longer need to collect quantifiable data on the backwardness of SCs and STs in granting quota and promotion. They just need to prove their inadequacy. They don't need data to prove their backwardness. They need data to prove inadequacy of representation. So there is a difference between need for data to prove backwardness and need for data to prove inadequacy. For example, let's say in a particular cadre of service, the state government collected data that out of 100 posts, only 5 posts are taken up by members of scheduled caste and only 2 posts are taken up by members of scheduled tribe. So this is the data to prove inadequacy. Data is not needed to prove their backwardness. They are already backward the moment they are categorized as scheduled caste or scheduled tribe. They are already backward. So data is just needed to prove inadequacy of their representation in a particular class of service or cadre of service. And hence it says, however, the states will have to back it with data to show inadequate representation in the cadre. Court said that the principle of creamy layer can be extended to members of scheduled caste and scheduled tribe for promotions in government jobs. when a court applies the creamy layer principle to scheduled castes and scheduled tribes, it does not in any manner tinker with the presidential list. So in this case, the court said that principle of creamy layer can be extended to members of scheduled caste and scheduled tribe. And finally, in the case of Devinder Singh, Supreme Court has said that yes, that categorization can be done. So today, let's keep it till here. I think we have discussed quite a lot of things today, particularly with respect to reservation. Krishna, overall you have an idea now. If any question is asked regarding reservation, I hope you will be able to attempt it. Okay. Okay then, see you on Monday. Any doubts? Yes, Krishna. Yes, Krishna, what's your doubt? Write few judgments as in? Yes, you have to. See, it depends on the nature of question, but if a question is asked on reservation, definitely you have to write the judgments. If you could remember, then please write. Some of the judgments are important. Supreme Court is, the UPSC is now started asking questions directly on Supreme Court judgments. We'll see some of those questions also. No. You just need to write the crux. For example, in Indira Sawhney, just the important point. For example, in Indira Sawhney, it allowed reservation for backward classes and also allowed for subcategorization, and further stated that creamy layers will not be entitled to any reservation under the OBC category. Further, Indira Sawhney limited the cap of reservation to 50%. Right? The important point. And did not allow reservation solely on economic criteria. That's it. So it will depend. Directly, you will not be asked to write judgments. You will be asked to write the change in reservation, or how has reservation impacted, or what are the constitutional provisions with respect to reservation. So then you have to write these aspects. So it depends on how the question is being framed. Okay. If you could remember, perfect. If you are able to write this, then nothing better than this. Okay, thank you.